Welcome to Broken Law, the podcast brought to you by the American Constitution Society, a 501c3, nonprofit, nonpartisan organization. I'm Christopher Wright Durocher, Vice President of Policy and Program at ACS, and your host for this episode. Today, I'm joined by Esther Sanchez-Gomez, Litigation Director for Giffords Law Center, to talk about U.S. versus Rahimi, the first Second Amendment challenge to make its way to the U.S. Supreme Court since that court's bombshell decision in New York State Rifle and Pistol versus Bruen nearly a year and a half ago. Gun safety advocates worried at the time that the Bruen decision would vastly expand the number and category of gun regulations that would be struck down under the Second Amendment. And according to one count, in the first 12 months following the Bruen decision, lower federal courts adjudicated about 400 Second Amendment claims to mixed results. On November 7th, the Supreme Court heard oral arguments in Rahimi, a case that could provide us insight into how the Supreme Court expects lower courts to apply Bruen going forward. Esther, welcome to Broken Law, and thanks for being here to help us break down this case.
Thanks so much for having me. Really glad to talk about this important issue.
So I want to talk a little bit about Bruen and why it's so important. But first, could you provide us some background on the Rahimi case in particular?
Sure. So United States versus Rahimi is a criminal case. It's a criminal case arising out of a district court in Texas challenging a federal law. So Mr. Rahimi is a man who is subject to a domestic violence restraining order. Domestic violence restraining orders are issued by state court judges, basically on a finding that someone is an imminent threat to an intimate partner or their children. And Mr. Rahimi definitely fits that category in a very sort of exemplary way. Some of the facts that came out ahead of time show that he fired guns in public to threaten people. He was violent with his intimate partner, those kinds of instances. And he's actually under indictment for a number of other crimes also involving firearms. So he's our paradigmatic example of the sort of person that we don't want out in the world with a gun. And certainly his intimate partner wouldn't want him having access to a gun. So he is subject to this domestic violence restraining order. And under federal law, while he's subject to this restraining order, he's not able to possess firearms. Law enforcement was investigating another crime in his home and encountered a firearm in his possession. And he was charged under 922G8, which is this federal law, and convicted. Following his conviction and the decision in Bruen, he decides to challenge the federal law under the Second Amendment. And the Fifth Circuit, in a very extreme decision, ends up striking down this federal law. That decision, applying Bruen, which I know we're going to chat about, so I won't get into too much detail, but takes it to the most extreme result in order to strike down this decision. And the concurring opinion to that reaches offensive levels in talking about the ways in which domestic violence restraining orders, which are an incredibly important tool for victims of domestic violence to protect themselves, basically implies that they are only tools used to manipulate and gain advantage in divorce proceedings, basically denying the lived experiences of many women and others who are suffering from domestic violence.
So you mentioned the Fifth Circuit, which struck down 922G8 as violating the Second Amendment. Now, if I'm correct, the Fifth Circuit originally upheld the law, and it was actually the release of the Bruen decision that caused the court to reevaluate that decision and then therefore strike down the law that it had previously, just a few months before, maybe a few weeks before, it upheld, right?
Yeah, so this law had been universally upheld by federal appellate courts, and the Fifth Circuit was the first to strike it down, applying Bruen. That's right.
So what is Bruen? Why did it cause this change, and why did it open up this opportunity to challenge laws like this that had previously not been subject to successful challenges under the Second Amendment?
That's a great question. I think to get to Bruen, we need to briefly chat about Heller. So if you'll forgive me to take even a few steps further back.
Absolutely.
So I like to say a bit jokingly, the Second Amendment as an individual right sprung out of the ground in 2008 with the Supreme Court's Heller decision. That was the first Supreme Court case in which the court announced that there is an individual right to own a handgun in your home for self-defense. Previous to that, the Second Amendment had really, at least in jurisprudence, been viewed as a collective right associated with the militia. And so from Heller, from 2008, so relatively recent decision, all of this kind of flows. And between 2008 and 2022, 2002, when Bruen was decided, there was only one other Second Amendment case, and that was McDonald, which incorporated the individual right against the states and announced that the Second Amendment right is the same as applied to the federal government and the states, that there wasn't any discrepancy there. So now we're in 2022, well, I guess 2021 when the case was argued, and courts around the country have been applying the Second Amendment using means and scrutiny, which we've seen in a lot of other constitutional doctrines. Courts are pretty good at applying it. And basically, we're balancing the individual right against a public safety or public interest to the contrary. And depending on how great the public need is, we can take greater incursions against the individual right. So 2022 decision in Bruen announces a new test, gets rid of means and scrutiny, and goes to what we've been calling the text, history, and tradition test. So text, history, and tradition no longer, at least by Bruen's terms, invites courts to consider public safety explicitly as part of the test, but rather the courts need to look to history to find an analog in our nation's history and tradition of regulating firearms in order to uphold the law. So this is a complete change in the way that courts are evaluating Second Amendment cases, but it's also a complete change from the way that courts evaluate cases generally. And so what's important about that is that what this test now invites them to do is to play historians. And if we look even at the Heller decision or at Bruen, the justices themselves, let alone lower court judges, are not terribly great at playing historians. I myself am not a historian, so maybe I'm not the right person to call them out, but a lot of well-respected historians have. And so I feel on pretty good footing to do so. But so this new test, I think when we talk about firearms regulation in this country and firearms regulation generally, technology and the way that it's changed and the way that our society has evolved is such an important piece of the conversation. And so binding future legislators to what past legislators have done is like a nonsensical, forward-looking approach. But nevertheless, this is the originalist approach that the justices announced in Bruen. And this shift invited a wave of challenges. As you might imagine, anytime a rule is changed, it's an opportunity to settle the law amongst the lower courts. But unfortunately, settling is not what happened here. We had a wave of challenges where judges across the country were considering challenges to laws that have been upheld for many years, even under Heller, and reaching different results based on the same facts. And Mr. Rahimi's case was the first one to reach the steps of the Supreme Court. And so this is really their first opportunity to take up what has created a mess amongst the lower courts.
So one of the things that was discussed a lot during oral arguments and was in the briefs as well was this question of, when looking at particularly history and analogs for history, the specificity that's required for those analogs. So could you talk a little bit about what the outer limits of that are, or what the expanses of those arguments between folks who would argue for the constitutionality of certain gun safety regulations and those who would argue against?
Sure. So I think that to talk about the level of generality that courts need to be taking, we need to start with the language of Bruen and take the justices at their word on some level. And maybe I should have mentioned this before, but Bruen was actually ultimately a fairly narrow decision in the result, in the judgment, because they were considering a challenge to a New York concealed carry permitting law. And really, they only struck down one particular feature that allowed discretion for issuing authorities and upheld the rest of the law, and expressly said that a number of other laws across the country that were similarly established were good under the Constitution. So it was a fairly narrow law that was struck down. And this new test was announced in the context of this relatively narrow decision. And the justices, by their own words, said that we're not looking for exact twins. So we know that that's too far. It doesn't have to be exactly the same law that has been on the books for 200 years, right? It's something further away from that. But how far was super open-ended. And as courts were dealing with this, at least in Bruen, we've seen them take a lot of different approaches. I think that one thing that we can start with in talking about this is like the notion of history and tradition. Is history and tradition like this general concept that we're just looking for guiding principles? I think that another sort of interesting question under that is, whose history and tradition? Because when we talk about legislation, what we're talking about is the people who were empowered to craft legislation, who were looking to benefit themselves from crafting legislation, who were looking to protect themselves, particularly in crafting this legislation. And even if you step outside legislation, the sort of historical record is always going to be influenced by who was or wasn't in power. And obviously our society has changed dramatically since the founding in that sense. And so that was an open-ended question. But even if we start to talk about just legislation, which some courts have taken that approach, how many laws demonstrate a tradition? Is it 3? Is it the majority of those presented to the court? Is it a population-based test? We've seen a lot of different approaches in that sense. And we've also seen different ways that courts have compared two laws. In Bruen, the court instructed that 2 relevant but non-exhaustive categories in order to compare these laws are the how and the why. I think it's worth noting that how and why sounds like a lot of like means and ends, that how being the means and the why being the ends. But then applying that, what is the why that a particular gun safety law is trying to achieve? Fundamentally, I think throughout history, we can say that was public safety. But our understanding of how to achieve public safety, our understanding of what public safety means, of who is protected by the institutions that are meant to protect public safety, has all evolved. So that was a long-winded way of saying we don't really know. Right. And the justices at oral argument in Rahimi are also trying to figure it out, I think.
Your comments remind me of a particular back and forth that Justice Jackson had with Rahimi's attorney when talking about relevant laws, historical laws, should be considered and those that shouldn't. I think part of his argument was that there was no evidence historically of complete bans on gun possession, but then it was noted that there were, particularly for Black people, enslaved people, Native Americans. And to paraphrase him and maybe not do him justice, essentially his response was, oh, well, those are repugnant laws. Like, we would never support something like that. Those are obviously like based on racism and things that we've evolved beyond, and therefore we shouldn't consider those. And I think Justice Jackson and maybe some of the other justices were frustrated by that, because then it becomes a question of like, well, then which history, as you said, which history does apply and which doesn't? Is there a sense that Bruen, as on its face, is just like it can't achieve those ends? It can't answer those questions? Is it too broad to actually do what it claims it to be doing?
That's a great question, and I think Justice Jackson did a great job of pressing Mr. Rahimi's counsel and even the Solicitor General on this point. How do we look at a history that is fundamentally racist, but also appeal to it in applying a future-looking test? I think that the appeal to these repugnant laws has been leveraged by both sides of the argument. If you announce a test where people are meant to be looking backwards to history to justify a law, that's what they're going to do. And when I was talking about we've always legislated with the goal of public safety, I think that there's probably an argument to be made that the goal of disarming formerly enslaved people was to protect public safety, but it was protect the public safety of those who were empowered. So we can't really talk about those historical laws without their relevant context. And that's a particularly important point also when we're talking about domestic violence, right? Like the way that our society has dealt with and addressed domestic violence over time has absolutely changed. And I don't think that Bruen really gave a clear answer as to how to deal with these sorts of tensions in history, appealing to a racist history. Justice Thomas, I feel like, touched on this, basically saying like, oh, well, we can't look to these kinds of laws. But I don't know that he gave a great reason for that, other than it's an easy way to dismiss a lot of historical laws that therefore give us a leaner version of history and tradition to rest on.
You're listening to Broken Law, brought to you by the American Constitution Society. If you're enjoying Broken Law, consider becoming a member of ACS today. You do not need to be a lawyer to be a member. As we discuss so often on this podcast, our laws and legal systems impact all of us. By supporting ACS, you support Broken Law, our work to diversify the federal bench, and our advocacy for Supreme Court reform. You also become a member of our nationwide network. Learn more about ACS by visiting our website at acslaw.org. And now, back to the conversation.
So I want to turn to the amicus brief that Giffords submitted in this case. You were on that amicus brief, right? And one of the, I think, interesting arguments that you raised in the brief in support of sort of a broad reading of Bruen and application of the Second Amendment to allow for gun safety regulations was this idea that armed violence or the threat of armed violence itself chilled other constitutionally protected activities. It harkens back to Justice Holmes' observation that the right to swing my fist ends where the other man's nose begins. Like there can't be this like Second Amendment absolutism that allows folks to have guns if it's going to actually chill others' constitutionally protected activities. Could you talk a little bit about that and how that actually incorporates the text history and tradition analysis that the court requires?
Yeah, and I love that quote, and I wish that I had thought to use it. It's a good one. Yeah, so what I think, and this sort of, I think, is an extension of what I was describing about history with its relevant context. As we appeal to history and as we talk about who was and wasn't part of the political community at the particular time, I think it's important that we always provide the relevant context and that we accommodate for taking the history and tradition and carrying it forward into new applications. So part of what our amicus brief argued is that women in particular, who are the primary victims of domestic violence, and that's not to say that men do not suffer from domestic violence, they absolutely do, but women in our society are the primary victims of domestic violence, and it's incredibly lethal to women. Women have not been part of the political community in the US until the 20th century. As women entered our political community and were able to advocate for themselves within legislation, we saw significant changes in the way that domestic violence was regulated in our country. And this protected not just their physical safety, but their ability to access these democratic institutions. And I think as the court, whether it be this court or future courts, consider legislation affecting the Second Amendment in the context of history, they need to be thinking about who we're protecting and not just the way that we're protecting it. And I think we talked about this a bit at the beginning, but if the laws are designed to protect the political community, women did not enter the political community well into the 20th century. And so we have to be considering that extensive history and adjusting for that relevant context as we apply this test.
So do you believe that a sufficiently broad requirement for the analogous test can achieve those goals? Were the court to identify that either in this or subsequent decisions?
I do think that the Bruen test allows for this kind of broad analysis. I think that the Solicitor General in her oral arguments in Rahimi made a really great case for this. And the terms that she used, I think, were excellent. So I'll just kind of paraphrase her. But essentially, what we need to be looking for in history and tradition are guiding principles. And those guiding principles can be applied with modern sensibilities. So when we talk about protecting the relevant political community, that's an important key, right? Today, the political community is much broader and much more diverse than it ever has been. And so if our guiding principle is to protect our lives and our democratic institutions, then we should be using the tools available to us to do that. And I think that Bruen, with the right context, can allow for those results.
Your comments there remind me of a couple of other points that the Solicitor General raised during her questioning. One was talking about looking beyond just gun regulations at the time and like other indicia of what the tradition around the expectations of regulating guns or otherwise expectations of where guns were and who could possess them. And then also something interesting that she said that I'd be interested in your thoughts on was encouraging the court not to give, I think what she said, dispositive weight on the absence of a regulation in assessing the idea that it would therefore be unconstitutional. This idea that just because they didn't outlaw something in 1869 doesn't mean they thought it was unconstitutional. They just maybe made the decision not to outlaw it. So I'd be interested how you think that argument was received and whether or not that can be a part of the jurisprudence as it exists.
Yeah, so I think that was a hugely important point. And To take your first question, I believe she provided that answer in response to Justice Kagan's invitation for a list of ways in which the justices could essentially correct Bruen. So hopefully Justice Kagan, at least, it was well received on her part. I don't know that I can speak to the other justices, but it's an incredibly important point, and I think it can kind of be boiled down to the justices shouldn't be inviting us to fall into logical fallacies. But really, the fundamental concept there is that, one, legislators don't always legislate to the outer bounds of their power to do so. I think any notion to the contrary would throw our current Congress into, a tailspin. Obviously, we're not passing all the laws that we are constitutionally able to do at any given moment. But in addition to that, and going back always to historical context, when a society doesn't experience a particular problem, there's no reason to legislate to fix it, right? Like, the only reason we legislate is to change the status quo. But if the status quo is acceptable to the particular political community in power, they're not going to legislate to change it. And I think that this can be both because technology isn't at a position where it's causing particular harm. That's not something we don't have legislation about how the internet should function before the invention of the internet, obviously, but that doesn't mean that the government doesn't have the power to do so, right? But it's also because cultural norms can affect the way in which we interact with each other. So for example, if you're in a particular community that's, especially when we're talking a couple hundred years ago in the US, mostly rural, smaller communities, kids weren't going to show up to school with their parents' gun. You didn't need to make a rule about it. It just wasn't going to happen because the cultural norms prevented it from happening, because the parents weren't going to allow it, because we're all on the same page. So we don't need to make those rules. I think that the final point, and the Solicitor General didn't touch on this, but I think it's relevant when we're talking about a deep dive into history, is that a lot of this history hasn't been uncovered. A lot of our sort of legislative and all of the other context history that exists from many of these time periods exists either only in memory that has been lost to time, lost to fires, or in archives across our country that have not been digitized, that have not been culled for this kind of information. And so we literally don't have access to it. And then back to my point about the way that women have played a role in our society and our sort of increasing participation, our understanding of history changes with our own context. Like I imagine that my history textbooks from elementary school do not look the same as my grandmother's history textbooks from high school, right? Our understanding of history adjusts as we understand new information and as we move forward. And in preventing that sort of logical fallacy where we make presumptions against the government will help avoid the impossible task of like proving a point that cannot be proven because there are no facts behind it, and avoiding the logical fallacy of making assumptions based on nothing.
I think Bruen is the law now, and it's unlikely that that's going to change dramatically in the near future. But I thought it was really interesting when that decision came out and the opinion talked about how difficult it would be for judges to actually apply some sort of balancing test. And it was outside of their expertise, and we couldn't expect them to do that. So instead, we'd expect them to become expert historians and have every attorney who wants to argue a case plumb the depths of pretty murky historical records, like you said. It just seems actually the exact opposite to me. I think that as lawyers, we're trained to like do these types of like interest balancing tests. That's like, or it was in law school, and history certainly is not where a lawyer's strengths lie most often, right?
Yeah, no, absolutely. And a number of judges have come out and said this explicitly. I think a couple nuance points to add there is the way that the court in Bruen framed up the burden, I think, is what invited these like false sort of assumptions based on no evidence. The Bruen court basically said the government has the burden of advancing all of the historical record. And so in that context, courts have said, okay, well, if the government has the burden of advancing an affirmative record, what do we do if they're not getting far enough? Like, what do we do with that information? And so the Bruen, I think, opinion invited this logical fallacy in a way that they absolutely need to correct. I think that the other interesting piece about this extensive record that courts are looking for and that government attorneys have been scrambling to put together with the help of just a few historians that specialize in Second Amendment law and historical context is that a lot of these cases are being decided at very, very early procedural phases. We're talking about preliminary injunctions. And so when we're so early in a case and you have to present a fulsome record or the law is going to be enjoined, it's another impossible trap of how do you collect enough of a record and not make inferences against the government in the absence of a record, but also have to decide the case with whatever's in front of you. It's a very odd sort of presentation of this kind of test.
So you just raised the issue of sort of like all the litigation that's happening at lower courts. I think I mentioned the 400 plus number of cases that have been adjudicated since Bruen. Could you talk a little bit about what types of challenges we're seeing, like what types of statutes or gun safety regulations are being challenged and how they're faring, to the extent that there's any sort of like consistent pattern to the results?
Yeah, definitely. And I would say that in terms of consistent patterns, every time I think that there's a consistent pattern, an outlier decision falls and then our pattern is lost. But I think we can divide the wave of challenges into what I think are sort of like three categories of cases. The first challenges came in the same sort of scope as the Bruen decision, as the law challenge in Bruen. And that's this either sort of public carry type laws and or sensitive places laws. Sensitive places, you can think about public carry laws and sensitive places laws as sort of like the interlocking pieces of a puzzle. Like either you're regulating who can have guns in public or you're regulating how big the public space is that people can carry guns in, right? And so New York, right after this feature of New York's public carry law was struck down, passed a broad sensitive places law, basically to protect from the other direction the spaces that didn't need to be protected when they were protected by the public carry law, right? And a number of other states have these sorts of laws or passed them in the wake of Bruen as well. And so those were the first wave of challenges. And the results in those cases have been super odd, with like splitting hairs of, well, yeah, we can't have guns in schools, but we can have them in summer camps. And so like, what's the dividing principle there? It's really hard to say. We didn't have summer camps in the 1790s, so no one needed to go out and learn what it was like to be outside of the city when there wasn't a city, right? So we're not talking about the same thing. Mixed results there, and there's still a number of those cases up on appeal. I'd say the next wave of challenges came in the form of who gets to have a gun. And this is the issue that Mr. Rahimi presents to the court, but it has taken a number of other different sort of shapes. One that I would highlight is minimum age laws. These were challenged all over the country. There was a wave of challenges happening in the run-up to Bruen. And since Bruen, that issue has been continually litigated. And so that presents an interesting question, because in Mr. Rahimi's case, they weren't really making this argument. But the minimum age question, which prevents people below a certain age from either purchasing or possessing a firearm in different contexts, presents the question of whether people below a certain age are even amongst the quote unquote people who are protected by the Second Amendment. And so that has been going all around and has also reached varied results. There is a class action that challenged a federal law that's now going on appeal. That'll be really interesting. It's the first one where I've seen an actual class allegations on behalf of a Second Amendment challenge like this. And then I'd say the final bucket of cases that are coming through are hardware challenges. And that's essentially like assault weapons or large capacity magazine type challenges. And those have also reached varied results. Just last week, the Seventh Circuit upheld the Illinois and various local jurisdictions that regulated assault weapons and large capacity magazines. But a district court in the Ninth Circuit struck down similar provisions just a few days before. So we're seeing it all over the map. Obviously, sitting before the Supreme Court are a couple of cases in that who category. We're challenging the federal felon prohibitor, as well as the law preventing people who are habitual drug users from possessing firearms. So those ones must be front of mind for the court right now as well.
Mm-hmm. Right. I was going to say those are two categories that we've certainly seen some action on in lower courts that are separate but related to the statute that's at issue in Rahimi. And so my final question to you, Esther, is what could the court do in Rahimi in crafting a decision to provide more clarity in terms of what Bruen actually means for gun safety regulations, and also to acknowledge the reality of, in this particular case, the fact that domestic violence was not even conceived of as a thing in the time when the Second Amendment was ratified, and therefore it's hard to create some sort of precise historical analog, but the need for safety is certainly real and vital. So what do you think that the court could do, or if you had a magic pen and you could write the decision, what would it look like to sort of cabin or clarify Bruen?
That's a great question. I mean, I was in the courthouse listening to oral argument a couple of days ago, and I walked out really, really optimistic that the justices, at the very least, all acknowledge that this is a grave public safety issue. And foundational to that is that the government has some power to regulate in this space. If I had a magic wand, I think it would be great for the justices to say super explicitly that the government has the power to regulate firearms when it comes to public safety. I mean, that's really what we're talking about. Our gun violence epidemic is really, really harmful to our society in so many different ways. People are living with the fear of gun violence on a daily basis. And I think that a decision that doesn't acknowledge that, I think, is just really untethered to reality. And in crafting sort of a legal test on that basis, I think that the court really needs to be taken into account that people are really suffering out there. And we need to be able to have the power to protect people in their homes, in public spaces, as they go to the voting booth, which I think is a hugely important issue in the coming year, especially given how our last election went. And so aside from all of these sort of more specific legal issues that we've been talking about throughout the course of this hour, I'd really hope that they put some humanity into this, because I think that would be an important signal to lower courts that they also get to keep their humanity in deciding cases going forward.
Esther, thank you so much for your time, and thank you for being on Broken Law.
Absolutely. Really happy to be here. Thank you so much.
And thanks to our listeners for finding Broken Law. Please be sure to follow and subscribe to Broken Law so you don't miss any episodes. And please recommend Broken Law to a friend so we can bring these important conversations to more listeners. You can find details and show notes about today's episode on our website, acslaw.org. Together, we'll speak truth to power about the law, whose interests it serves, and whose it does not.